9.13 of the Ohio Revised Code by the Anderson Township trustees to provide administrative relief to any person or entity adversely affected by the Anderson Township Property Maintenance Code. Will the secretary please call the roll?
Brian Ellis.
Here.
Steve Faber.
Here.
Fred Hayes.
Here.
Rick Oversmith.
Here.
Brian Johnson.
Here.
Thank you. Thank you for coming to this meeting of the Anderson Township Board of Maintenance Appeals. Please be aware that this meeting is audio and videotaped and may be carried live on television. First, I'll outline our procedures. A summary of the appeal is presented by the staff. Then the appellant will present its case. The board members may then ask questions of the appellant. After that, all persons supporting the appeal will be permitted to testify one at a time after being recognized by the chair. When those persons supporting the appeal are finished, those opposed to the appeal will then be permitted to testify and/or ask questions of the board after being recognized by the chair. All persons wishing to testify, whether for or against the appeal, may only do so after being sworn in. When testifying, each person must come forward to the podium after being recognized, speak into the microphone, state their name, address, and any affiliation with the case. All persons testifying will be limited to four minutes unless the board member requests additional time. All testimony is given to the board only. No comments or questions are to be directed to the appellant or anyone else in the audience. The board will hear new, non-repetitive evidence or questions. Should someone wish to show support of previous testimony, they may do so by following the testimony procedures and stating their support of the previous testimony. Now, will all persons who may give testimony this evening please stand, raise your right hand. So who's going to testify tonight in the property maintenance case? If you think you're going to testify in the property or any of the cases, why don't we go ahead and stand up so there's no confusion. If you think you might, please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Okay, thank you. Please be seated. Are there any changes to the agenda tonight? Okay. And could you, Ms. Hodson, please read us the case summary for Board of Maintenance Appeal item case 1-2014 BMA.
Sure. The applicant in this case is Michael Clancy and Nadia Cheng, the property owners of 7258 Royal Green Drive. The zoning of this property is A2, which is single-family residence. And the request before us this evening is an appeal of Section 303.2 of the Property Maintenance Code of Anderson Township. This is a location map showing the subject property as well as the surrounding zoning, which is A2 on each side. To the east, there is also a trail. Planning and Zoning received a complaint and inspected the property on March 1st of 2011, and the property was found to be in violation of Section 303.2 of the Property Maintenance Code in regards to protective treatments. We notified the applicant of this through the mail on March 1st, 2011, and this notice also contains steps necessary to correct the violation. The options being to paint the exterior of the home as well as trim within 60 days or contact the Planning and Zoning Office within 20 days to present a strategy for correcting the violation. On October 2nd, 2012, a letter was sent to the property owner to inform them that the property was still in violation and gave the owners 30 days to correct it, or again 20 days to contact the Planning and Zoning Office. The applicant was again notified of the property violation on August 18th, 2014. This citation required that the exterior of the home be painted within 14 days. We received a notice that the applicant would like to appeal the violation via email on September 17th, 2014. Staff confirmed this appeal request through the mail as well as a letter posted to the property on September 29th. Again, the applicant was notified of the hearing date and time on October 7th through a certified letter, and October 21st through an email to confirm the date and time of the hearing. And we have on the screen several photos of the subject property.
Okay, thank you for that summary. Does anybody on the board have any questions for Ms. Hodson? Okay, hearing none, would the appellant like to come forward, state your name, address, and provide us your information on the case, please?
My name's Michael Clancy. I'm the property owner in the property in question, 7258 Royal Green Drive. We have lived in this property since 1995. When we purchased the property, it had been recently painted at that time. Unfortunately, and I'm no expert, the way the property had been painted in the year prior to that caused a lot of damage in terms of the ability to paint to adhere to the surfaces to the existing siding. Since then, we've had the property painted twice, most recently in about 2003, 2004. The paint started to fail a few years ago, partly because of that same problem from the original paint job in the mid-1990s. Currently, the property is under contract with a professional painter named Terry Downey. I have hired him. He's done prep work. He's done most of the cleaning of the surfaces of the house, a fair amount of the scraping, and looks to be able to complete the painting of the property, weather permitting, by the end of this month. Of course, it's November, and weather is very much iffy this month. But he is committed to complete the painting of the property if the weather permits this month. If not, then he can at least do the prep work and get a undercoat on the entire surface of the house. It's a brick house. The first floor is brick. We're only talking about the second floor, a garage door and some trim. So we hope to get that completed, like I said, weather permitting, by the end of the month. He's been working on the property for about 5 or 6 days now. I don't really have anything else.
Any questions for Mr. Clancy? I just had a couple for you. We see, I guess, the 4 pictures up on the house. That's your residence, correct?
Correct.
Okay. And now you just mentioned that you've had some prep work done for painting. So is the house in a different condition than where we see it here, or does it look the same?
Well, probably about 75% of the back of the house is in pretty good shape. The front of the house, mediocre. The sides are really an issue. The sides of the house at this point have been pretty much scraped clean of all loose paint. The same with the back. The front still needs to be done. If we have a sunny day or 2 this week, that'll be complete. So basically, any kind of loose, as the paint kind of bubbles up, that's probably about 75% of that bubbled up paint has been taken off at this point. Some caulking needs to be done with windows and things like that. Basically, a lot of the work that can be done in kind of inclement weather can be done in the next 2 or 3 days, and that's the completing of the scraping and the prep work. The painting itself is that undercoat is what really we're waiting on for a couple of sunny days at this point. But yeah, the condition of the house has changed since these photos were taken.
What did the painter say he was going to do different? Now, you said that the condition of it was due to some failures of some prior treatments. What's the fellow doing different?
My understanding is when this house was put up for sale in 1995 and we purchased it, somebody had slapped on quickly a very quick and dirty latex coat over oil-based paint. It didn't adhere. And not only that, but it created, this house was built in 1966, so there's several layers, but what my painter is going to do and is in the process of doing is getting this down to the bare wood, the problem areas, getting it down to the bare wood as much as he can so the paint can adhere. You can slap up paint, of course, and it will look good for a few months, maybe a year, but if it's over a surface, it shouldn't, if you're mixing paints, then it's just going to fail. Mm-hmm. And that's been the problem we've had in the couple of paint jobs that we've had in the 15 or so years, 16 years we've been in the house. But fortunately, we've got someone who can identify the problem and has identified it, and we hope this won't happen again.
Sure. Now, the staff remarks we have show that the original complaint was from 2011. Mm-hmm. Can you explain to us what What was going on between 2011 and when we're here today?
Well, we talked to several painters, but we didn't really feel confident that they basically just wanted to paint the house. And I didn't want to have to do it again in 2 years, and I really needed to find somebody who could find out what the problem was. And so everyone we had to look at the property, and including somebody we almost had under contract earlier this year, and then we kind of revoked the contract when it was clear that they were just going to basically put up a coating of paint over already bad paint, and it wouldn't adhere. So,
Thank you. Any more questions?
Yes, Mr. Chairman. So is it your intent, and does the contract currently cover bringing the house up to an appearance that would meet the standards of the neighborhood?
oh, absolutely. I mean, it's, at the very least, this month we'll get an undercoat on, which is not going to be the final color. That's without question. The question is, will we be able to put the second coat on in time? We have good weather for that, and of course, that, as my painter explains, we need really good weather for that, and you know, it's possible that wouldn't happen between now and the end of the month, but certainly with the undercoat, we're going to talk about a uniform color all around the house, sealed windows, sealed, you know, caulking and everything else, so the house will look great with that on. It's just, it won't possibly be the final coat. We're going to change the color of the house dramatically, so whether that second coat gets on in the next, I hope it gets on the next 3 weeks. That's my painter's intent, but...
Then may I ask you what you are appealing here tonight?
That's all I have to say.
I have the same question. Are we appealing something tonight, or are you telling us that you've received this communication and you're proceeding forward?
I mean, basically, I received this notification back in August, and I wanted to appeal it because I wanted to have an opportunity to talk to the board, to tell them what I'm telling them now. I was hoping it was going to be done by now, but we've had a very rainy fall, and that's held back my painter. So I was hoping it was going to be complete by now. It's not. We had a few sunny days here and there in the last couple of weeks, so my painter was able to get started. But
Do you have any other photos that you've brought with you of the
No, I don't.
property or anything? Okay. All right. Any more questions? Maybe one more?
But we'll keep the public open.
Okay, thank you.
Thank you.
All right. Is there anybody else here in support of the appeal? Anybody here in opposition to the appeal? Is there some additional information from staff?
We do have Tom Crusoe here if you've got any specific questions for him.
Yes, I have a question for him. Now, Tom, you've been out on this property and inspected it, correct?
I was there today.
Okay. Do these pictures represent what it looks like today?
Yes, in my opinion, it still looks like that today.
Okay.
We heard testimony that there's been scraping and primer of some sort on the property. Are you saying that you did not see that?
I did not see that today.
Okay. Thank you.
Did you take any pictures today?
I did,
Do we have those?
and Allison has them.
Thank you. Ms. Hudson's given me some pictures with today's date on them of the house. I'll pass those down. Was anybody there working on the house today when you stopped by?
It was raining today when I drove by.
Right.
Did you see any evidence of material or equipment for any painting work?
I did not see anything like that.
How do you get testimony from other people here? Or even if you want.
We'll ask Mr. Clancy to look at those photos, maybe. Thanks, Mr. Crusoe.
You're welcome.
Mr. Clancy, could you come up and look at these photos for us? They're dated today's date. Can you, those are from today, would you agree?
I have no way of, other than the timestamp at the bottom, I would assume they're probably correct.
Can you explain to us, in your view, how what we see on here differs in that photo? Those
Well,
photos?
first of all, there is painting equipment in the backyard. There are sets of aluminum ladders, cans of primer. There's not primer on the house. I just want to correct any misinterpretation. My painter has basically been doing the prep work. He's power washed the property, the upper level. He's done scraping. There are mounds of scraped paint waiting to be cleaned up on the side of the house that are not visible from these photos, which appeared to be from the street level and not actually on the property. And the painting equipment is on my back deck.
Okay, thank you.
So that's,
Thank you very much. All right, there being no further, anybody here to testify on this, we'll go ahead and close the public portion of this hearing. Mr. Powell, do you want to discuss this now, since this is a proper meeting of the Property Maintenance Appeal Board, and just, you know,
Well, I think
how
there's-
would you like us to, how would you recommend we proceed on that?
I think that, you know, you've got the notice of violation that states the violation. The appeal doesn't refute the information in the notice of violation, so I think that the board is within its rights to determine that there's been a violation of the property maintenance code, and then the board would have the discretion whether they wanted to, you know, let the notice, or I'm sorry, the enforcement of the matter sit for a little bit of time to give Mr. Clancy the opportunity. Obviously, as you pointed out in your questioning, that this has been going on since 2011. So I think that if there is a deferment of any execution on the notice violation, it should be relatively short.
Right, okay. Thanks, Mr. Powell. So in our materials that were provided to us, there is a property maintenance notice of violation dated August 18th, 2014, one dated October 2nd, 2012, one dated March 1, 2011, and we have in our materials blow-ups of the same photos that are on the screen, and then we have the 3 additional photos that we received today that Mr. Caruso indicated reflect the conditions on the property today. So we'll go ahead and close the public portion and open it up for discussion of the board on the merits of Mr. Clancy's appeal. The question being, is the property in violation of Section 303.2 of the Property Maintenance Code? And just could you just read that for us, what that section says? That would be maybe helpful.
2 is protective treatments, and it reads, "All exterior surfaces, including but not limited to doors, door and window frames, cornices, porches, trim, balconies, decks, and fences shall be maintained in good condition. Exterior wood surfaces other than decay-resistant woods shall be protected from the elements and decay by painting or other protective covering or treatment. Peeling, flaking, and chipped paint shall be eliminated and surfaces repainted. All siding and masonry joints, as well as those between the building envelope and the perimeter of window, doors, and skylights shall be maintained weather-resistant and watertight. All metal surfaces subject to rust or corrosion shall be coated to inhibit such rust and corrosion, and all surfaces with rust or corrosion shall be stabilized and coated to inhibit future rust and corrosion. Oxidation stains shall be removed from exterior surfaces. Surfaces designed for stabilization by oxidation are exempt from this requirement."
Okay. Thanks for reviewing that for us. So that kind of lays it out, what we're looking at. And question is, on this appeal is, does the condition of the house meet that standard, or does it not meet that standard? Now, the notice of violation says it does not, and what the board needs to decide is that correct, or is the appellant, who has appealed that, is indicating that there isn't a violation of that? So I'll turn it over to the board to discuss, and we can also touch on the possibility that it's in the process of being repaired as well.
Mr. Chairman, my view on this is that as of today, and as of this week, I drove by several times, I do not see the basis to overturn the decision that the property is currently not in compliance with Section 303.2 of the Property Maintenance Code. So I would be very comfortable with the board making a decision that the property is not in compliance with 303.2, and the appeal is would not be sustained. That's a different question of whether if the board makes that finding, whether we have a relatively short period of time to allow the applicant to come into compliance. Obviously, a situation that's been bouncing around for 3.5 years, I think we have to look a little jaundiced about how fast the corrections are going to occur. But in terms of whether it currently meets the standards, I don't see much of a, in my mind, it is not in compliance with 303.2.
Okay. Thank you, Mr. Overschmidt. Other comments?
I'd have to agree with that. I think there's definitely a violation, but I also would support a short period of time to correct it.
Mr. Chairman, I completely agree with those findings. It is clearly in violation. I listened to the testimony clearly, and I find no grounds for a real appeal. The appellant did not really state that they're appealing the findings at all. So I think it is clearly in violation, and since it has been going on for so long, I would be in favor of a fairly short period for corrective action, maybe in terms of number of sunny days.
All right. Mr. Haber?
Yeah, I just wanted to say that I concur with everything, and especially what Mr. Hayes just said. I didn't hear anything from the appellant that indicated he was appealing the violation. In fact, he's indicated he's taking action towards remediation. So I am in agreement with the rest of the board here that we give him a short time frame in order to correct it and to bring it into compliance.
Okay. Mr. Powell, and I agree with those comments too. Mr. Powell, now, we could certainly make a motion and find the violation, or assuming that would be the finding. We don't know till we vote on that. Or we could continue the case till next month and make the finding. Does it really matter if we make a finding now and continue it? It seems like if we do that, the case is over. But if we If we don't make a finding and continue it, then we will see Mr. Clancy back here. We will invite him to come back next month and, see what happens.
Yeah, Mr. Chairman, I think either way is fine. If you do postpone the decision until next month, I would invite Mr. Clancy to, provide evidence of what's going on in the meantime. Hopefully, he'll be able to, inform at least the staff that, the issue's been taken care of. I think that should then be entered into the record in this case, whether Mr. Clancy has to be here or not, but it should be entered into the case just so in the event there's further issues with this property, at least that's on record that, there had been a violation that had been remedied. And, but so I think it's up to the board at their discretion whether to go ahead and uphold the decision of the staff at this point or whether you want to put that off till the next month.
Yeah, sure. Thank you. I guess I could go either way on it, but I guess my feeling is that if we don't make a decision tonight, there will be some obligation by Mr. Clancy, if he chooses to take us up on it, to come back to us and report. If we take action tonight, then I think we could ask him to come back, but he really doesn't have any obligation to, so I would suggest we continue it till next month, but I'm open to other suggestions from the board.
I think Mr. Oberschmidt indicated that this thing has been going on for 3 years or so. It's been taking a long time to get to this place right here, and my preference would be that we make a decision and give the appellant a certain amount of time to correct it, whether it's 30 days or what. I don't know what that next step is, but I think we ought to uphold the decision of the report that we have and mandate correction ASAP. You said number of warm days. I'm looking at the calendar, and it looks cold over the next couple weeks.
I was proposing sunny days, ones that, even if it's cool or cold, could still be useful for painting.
But I don't know then what that next step is. If he doesn't, if the appellant does not comply within that time frame, what's our next step?
Good question.
Well,
Yes,
the
Mr.
two-
Chairman, can I ask a question of counsel?
Yes.
Mr. Powell, to the extent that we make such a finding today, if we condition, are we able to condition its enforcement, or do we have to make another finding next month if staff reports that it's not been remedied?
You can condition as long as the condition's, reasonably related to the violation, obviously, as far as corrective action, something like that. The two penalties under the code are a civil citation, which is a $100 fine per day, or the right for the township to proceed under 51924, which is the ability for the township to seek an injunction, in this case an affirmative injunction, to require him to paint the structure. That obviously would take a little bit more time to get because you'd go through the court process. But that's the option.
Okay, thank you.
All right, so it sounds to me like the board would like to make a decision tonight on this, so would somebody like to make a motion finding if the appeal is well-founded or not well-founded, and whether this board supports or does not support the finding of the staff of a property maintenance violation for this property?
Mr. Chairman, I move that this board find that the property is in clear violation of Section 303.2 of the Property Maintenance Code of Anderson Township, that we confirm that finding, and that we offer secondly, the appellant gave no real reason for changing that finding, and and is in fact in planning to correct the situation. And so we should allow him 30 sunny days to have the corrective action completed in the form of at least a good appearance, maybe not the final painting finish.
Second? All right, there's no second. Somebody like to form another motion?
I think that my hesitation with Mr. Hayes' motion is only how to define the timing of the next steps.
Okay.
I'd be more comfortable with a motion that said that within 30 days that the stripping of the paint and the primer, evidence of that be applied, and that within some reasonable period thereafter, the final, depending on whether the final coat be put on. In Cincinnati, 30 sunny days could be next April for all I know, but it doesn't take them 30 sunny days, it probably takes them 3.
Exactly.
If there's somebody who's really there working.
Right.
So that was my only hesitation of why I
Sure.
hesitated to second that motion.
Makes sense.
I would limit that to 30 calendar days, and then let the appellant come back to us and say, it was unable to be done. You put 5 guys on this house, and they'll do it in 2 days. So my thinking is, let's just give him 30, that we find him in violation, the appeal is denied, and we give him 30 days to bring the property back into compliance. That's my feeling.
Yeah, I would agree with that.
And I move that.
Okay.
Second.
Okay, so we have a motion that the appeal of the staff finding of a property maintenance violation is not well-founded, that there is a violation of 303.2 of the Anderson Township Property Maintenance Code, and further, we give the appellant 30 days to come back to the board to demonstrate that the work has been completed and the property is no longer in violation of the code. So the motion was made and seconded. Any further discussion on that? Okay. Roll call?
Steve Haber,
Aye.
Fred Hayes,
Aye.
Rick Oberton,
Aye.
Brian Johnson,
Aye.
Brian Ellis.
Aye. Okay, thank you, Mr. Clancy. We look forward to seeing you next month. Good luck with that.
Thank you.
Okay, so now let's,
We're going to close the
yes, there's a motion to close the,
adjourn.
move the adjourn the Property Maintenance Board. Have a motion from Mr. Haber, a second.
Second.
All in favor?
Aye.
Aye. Opposed? Okay, we will adjourn from property maintenance and move on to Board of Zoning Appeals. Thank you, Mr. Powell. All right. Do my next thing here. All right, now, for those of you who have been here, which is most of you, you will have heard this largely already, so I'll summarize it. But now we are convening the meeting of the Anderson Township Board of Zoning Appeals, and this meeting's hereby called to order. The board was established pursuant to Section 519.3 of the Ohio Revised Code by the Anderson Township trustees to provide administrative relief to any person or entity adversely affected by the Anderson Township zoning resolution. Secretary, please call the roll.
Brian Ellis.
Here.
Steve Haber,
Here.
Fred Hayes,
Here.
Rick Oberton, oh gosh, Rick Oberton.
Here.
Brian Sanders, or Johnson. All up.
Here.
Okay, thank you, Betty. All right, now, thank you for coming to the meeting. Still is audio and videotape may be live on television. Procedures, a summary of the appeal will be presented by staff. Appellant will present its case. Board members will ask questions of the appellant. After that, all persons supporting the appeal will be permitted to testify after being recognized. those persons are finished, anybody opposed will also then be permitted to testify. All persons wishing to testify, whether for or against appeal, may do so only after being sworn in. Testifying person must come forward to the podium and be recognized. State your name and speak into the microphone. Ask that questions and comments be directed to the board and that the board hear new non-repetitive evidence. Now, would anybody who wishes to give testimony please stand, raise your right hand, and swear or affirm? If you think you might testify, yep, go ahead and do it again. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you very much. Yep. It's unusual for us to have 2 hearings like this, so we apologize for all the extra process. So we'll jump into the first BZA case, 11-2014. Allison, could you give us
Let's do minutes?
Minutes?
Yep, we'll do minutes first.
Yep.
Sorry about that.
I did receive corrections from Mr. Eliff and Mr. Oberschmidt.
Okay, and I just had a quick typo on one of the paragraphs. Anybody else have anything on the minutes?
Move we accept as amended.
Second?
Motion and second to approve the minutes. Discussion, roll call. All in favor?
Aye.
Any opposed? Okay, and we've approved the minutes. All right, thank you. And now we'll move on to case 11-2014 BZA.
Yes, the property is 2070 Anderson Cove. The property owners are Scott and Joyce Gundling. It is zoned B residence, and the request before us this evening is a variance from section 171.7 of our zoning resolution to allow an outdoor fireplace to be located a distance of 2 feet 4 inches from the rear property line where 3 feet is required. We have a location map of the subject property here. Surrounding zoning is B residence to the north, south, and west, as you can see here. However, it is B/AACUP Community Unit Plan to the east. The tract is .377 acres and has approximately 158 feet of frontage on Anderson Cove Lane. It is relatively flat, and the existing use is a single-family home. We have an aerial photo of the site. The proposed development is that the applicant is constructing several rear yard amenities, which include a basketball court, in-ground swimming pool, patio, and outdoor living area with stone fireplace. The single-family residence was issued a zoning certificate in 2004, and the applicant obtained zoning certificates for the pool, patio, and accessory structures, which include the outdoor living area and fireplace, in 2014. At this time, the applicant used a survey from 2004 to identify where the property lines were located and began construction of the projects accordingly. In September of 2014, with construction underway, it was discovered by the applicant that this 2004 survey was not accurate. A second survey was performed, which showed that the partially constructed outdoor fireplace was located a distance of 2 feet 4 inches from the rear property line, where that 3 feet is required. At this time, other structures were able to be modified to meet the 3-foot requirement. This is a proposed site plan here on the bottom of the original zoning certificate that was issued for the outdoor living area. And then on the top, we have a copy of that new survey for you. Staff finds that the variance is not substantial. The applicant is requesting a reduction in setback of 8 inches, and the essential character of the neighborhood would not be substantially altered, and adjoining properties would not suffer a substantial detriment as a result of the variance. As we can see from the aerial photo, other properties within the area, for example, on Knightsbridge, Clough, and Harcourt, have outdoor amenities such as pools, decks, gazebos, etc., which can be located 3 feet from the rear and side property lines. A distance of 2 feet 4 inches will not substantially alter the character of this area. The variance would not adversely affect the delivery of government services. And finally, the property owner's predicament cannot be feasibly obviated through some method other than a variance. The applicant was able to move the location of the pool to meet the setback requirement and has explored several options to bring the fireplace into compliance. These include trying to purchase property from an adjacent owner to meet that 3-foot setback requirement, as well as looking into the cost to deconstruct and move the fireplace. The adjacent owner was not interested in selling a portion of the property, and the cost to relocate was prohibitive. If you have any questions? We've also got photos of some of the projects under construction from mid-September, as well as more recent photos of the fireplaces further along, with the stake here showing the location of the, where the 3-foot setback would be in relationship to that existing fireplace.
Okay, thank you. Is there any questions for staff on this at this point?
One quick question, if you know it, Allison, was how was it found, how was it determined that the property line was 8 inches off?
I believe that the adjacent neighbor had some concerns about the location of the structures, so in looking at where they were in relation to the property line, it was discovered that the survey was off.
Okay, thank you.
Okay, any more questions? Is the applicant here? The Gunlings? Would you come forward and identify yourself and give us your comments, please?
My name is Scott Gulling, and I am the owner of 27D Anderson Cove Lane, and making the appeal.
Okay, pretty much what staff
Exactly
said?
how she stated it.
Okay. Does anybody have any questions for Mr. Gunling? Mr. Oberschmidt?
Yes, sir. When you laid out the location of the fireplace originally, it was based on a survey that turned out to be mistaken? Is that what we understand from the materials?
That's how I understand it, yes.
Did you have a contractor that was working with the survey, or how did they get laid out?
Yeah, we have a contractor that was using the plat to lay out all the amenities.
And the fact that this is, the fence that's there, is that fence on your property or the property to the rear?
It is on the property to the rear. It is not our fence.
Okay, and will there be enough space based on where the fireplace is located for you to maintain your part of the property behind the fireplace? Is that wide enough to get a lawnmower and those kinds of things through?
I believe it would be, and there will be no grass on our property there.
Thank you.
Mhm.
What's the width of the fireplace?
It's, I believe, 7 feet.
I didn't hear you. What did you say? I'm
I
sorry.
believe it's 7 feet.
7 feet wide?
Yeah. I think that's stated in one of the descriptions here.
How did it come about? I understand how it came about, that there was a question raised by the rear neighbor about how close it was. But at what point in the construction what brought that conversation about, and at what point were you in the construction when that question was brought up?
At that time, the fireplace had been constructed, and the landscaper had suggested we contact the neighbor behind us to see if they would want to do anything to improve the grading between the two properties. And so then we invited them out to discuss it, and, they called in question that we were in violation.
Okay, understand.
A quick question I have is, when was your house built?
2004.
2004, okay.
Did the contractor, when the contractor was building the fireplace, I think it said in the remarks too somewhere that there's some pins out there. How did the contractor, if you know where to place the fireplace to begin with?
I'm sorry.
I was going to say, because they relied on a survey that was incorrect, but how did they do that? I mean, it was just on paper, wasn't it?
Well, I can answer the question. There are pins, but I do not know how they determined where the property line is and how to offset the fireplace.
Okay. Any more questions for the appellant? No, okay, thank you.
Mhm.
Okay, is there anybody else who'd like to speak in favor of the appeal? Yes, sir, could you come up? And give us your name and address, please.
My name is Raymond Nell Honeycutt. I live at 2057 Harcourt. I am not exactly behind him, but next to him, kind of adjacent.
Yes.
I would like to see them get the variance for two reasons. One is if the variance isn't granted, from my understanding, what they have to do to be within their 3-foot means would affect the rear of that, which would affect my view. So selfishly, I would not like to see that at all. The other is, I was a real estate broker for 20 years, so from a value sense, that would affect their property and mine as well, if in fact the way that that is to be corrected will alter the whole final finishing of it. So I would love to see it. But that's just my 2 cents worth.
Okay. Any questions from Mr.
Yeah, a quick question, sir. When you said that your view would change, there's an assumption of what that view would be. Can you tell us what you think that view would, how it would differ?
My understanding is in order to come into compliance, they would pretty much have to strip the stone off of that, which would probably leave the cinder block, which is just the base.
I understand. Thank you.
Thank you.
Okay. Thank you. Okay, who else would like to speak in favor of the appeal? Yes, sir. Could you come up? Your name and address, please.
My name's Jeff Senna, and my address is 626 Charwood Drive, Cincinnati, Ohio, 45244. I represent Bezak Landscaping. We're constructing this project in compliance with REIS. And the original measurement was taken off the back of the house from the plot plan, and that's where we determined how to set the fireplace where it was. Come to find out afterwards, the house had actually been placed 6 inches further back than what the plot plan showed. So we took a hard measurement right off the foundation of the house and determined we were within the 3-foot offset in order to build the fireplace. And in my opinion, we're making improvements to the area. It's a beautiful fireplace. It's very well built, and it could be altered by taking the stone off the back and enlarging the block so that it's just a cement fixture that would function well, but would be aesthetically unpleasing. And that's why we're here in favor of the variance.
Very good. Any questions for Mr. Senna?
The question about the location of the pins, did you locate the pins? Are the pins accurate or inaccurate?
I can't answer that to my knowledge. I can't answer that as much as I'd like to. The gentleman I work for did the initial measurements. I wasn't there that particular day.
Any more questions? Okay, thank you. Who else would like to speak in favor of the appeal? Who would like to speak in opposition to the appeal?
Can I say one thing on the pins?
You come on back up, though, if you would. This is Mr.
I don't know
Honeycutt.
if this has merit or not. I think the pins that they're referring to are my pins because I had a fence put in my house. We built our house in 2004 as well, and then we put a fence in probably 2005. So we had it surveyed in the back, and my fence is actually 3 feet up from my property line because I have trees. So my pin is the pin that you see sticking up there. That was the most recent one.
Hey, Allison, could
Just
we
the-
bring up the subdivision? I'd like to see where his house, where's your house relative to the red
Do you
star?
see the house with the pool?
Yeah.
Okay, mine is to the left of that. Correct, right there.
Right there, okay.
Yes.
I got you.
And it really, if you look at that photo, it doesn't look like I have much of a view into their, but we've taken 37 trees out of that backyard. So it's very open. Excuse me.
Okay,
And so
that
we
helps.
do have a view right into that area.
Sure, okay. Okay, thank you.
Thanks.
Okay, now, anybody that wants to speak in opposition to the appeal? Yes, sir, could you, there's a couple, we'll have you come up.
Mark Stoffregen, 2075 Harcourt I'm directly behind what I would term their side yard. So to the right of the house with the pool.
Is her cursor on the right house, or, yeah, to the right of the pool? Okay, we got you. Okay, go ahead.
That one, okay. Well, as regards the pin, I can't say, when Ray's was placed, but mine's been there for about 19 years. It's permanent, the rebar stake with an orange. And I know that it's accurate because I had it surveyed twice to make sure by different surveyors. So I'm pretty confident that they ended up at the same place. And there's a pin at the other side of my yard. And I wouldn't be here at all except for the fact that when they excavated the pool and had that big mound of subsoil, that they spread it all over it, including an incursion approximately 15 feet on my property, which was subsequently and later on removed. But also, they had several trees that were on my property that they cut down. So they, I don't think they were really aware or concerned with where the property lines were. I also called the Hamilton County Water and Soil Conservation to see about the erosion, because this was done, I think, toward the end of September, but October is characteristically a fairly rainy month, and so there's been a noticeable amount of soil erosion onto the back of my lot that was unabated, despite the fact that everybody was clearly made aware that that was going to become an issue. So, I can't speak directly to the fireplace issue, but my general sense is that there was a disregard for where the property lines were, and anybody that's been in the business for 15 or 20 years, I think, knows enough to know to determine where the property line is, not just kind of where it is. That's all I have to say.
Any questions for Mr. Stoffriding? No? Thank you. Yes, ma'am. Could you come up and give us your name and address?
My name's Vernita Leslie. I live at 2067 Harcourt. We're directly behind. We're the one with the pool behind them. And there are rebar pins on either side that have been there, and we do believe that those are the property lines. They were there prior to all of this. And when we first approached them, we said, where is the property line? And they could not point it out to us. So we showed them where the rebars were. That's one. The second is, I did contact my real estate agent and said, I'm concerned for my property value, because when you look out my back door now, you have 3 massive structures. And she said, potentially, yes, we do have some property value decline. And my third statement to you guys is I know that 30% of a structure cannot be bigger than the backyard. But the way that I think the intent of the law is that you can't have 3 or 4 that each are 30%, that it was 30% of your backyard should be structures versus what we have now.
Could you give me your name again?
Vernita Leslie.
Vernita Leslie.
Mm-hmm.
Any questions?
I did have a question. If the fireplace structure was moved 8 inches, does that change the impact on the value of your house? Thank you.
No. It's the whole, the 3 together, that when you look out, you see 3 structures. And if you look, their backyard is very small, very tiny. And it's pretty much, when I first came, there was an injunction that they couldn't work. We went on vacation. I assumed that all of the rules were going to be looked at. Didn't realize that it had been approved. So when I came to talk to the township, the drawings that they had at that point in time had the pool 5 feet. The edge of the pool 5 feet from the property line. And I said, there's less than 3 feet. That's when they came out and surveyed the property again, and then put an injunction in. So there's been several times where they continued to work when they knew that there was questions and problems.
So when you talk about the structures at 30%, so you're talking about the fireplace structure, the swimming pool,
And
there's
the
a couple other things going on out there,
And the
right?
basketball court.
The basketball court.
So
Okay.
the way that I was explained is that as long as you could have 5 things or 10 things, but as long as each one was under 30%, it's okay. But I don't, and I know that this isn't for, but I would encourage you guys to go back and look at the intent of the original 30% is that we don't live in the country and want all these structures built to protect our property values.
Okay. Very good. Any other questions? No? Okay, thank you. And who else would like to speak in opposition to this appeal? Okay, nobody else? Okay, so Allison, what about her question about each structure, if you will, being 30% as opposed to 30% aggregated?
Sure. The way that it is written in our zoning resolution is that any accessory structure can be no larger than 20% of the required rear yard area of a property. We don't actually use the calculation of what someone would determine their rear yard to be, from their back property line up to their home. We actually use a calculation based on 30% of the required rear yard area, which is the required rear yard setback of the zoning district. We've seen a couple different cases for accessory structures such as this, and have kind of gone through that section of the code before.
So no single structure can exceed 20%
Of the required rear yard area.
of the required rear yard area, but you can aggregate them apparently, correct? Okay.
And just for clarification there, Allison, that is section 171.7 of the code, is that correct? Yeah, and that is the approved code. We live with it. Right, okay, thank you.
Okay, any other questions for staff? Okay, we'll go ahead and close the public portion of this hearing. Thank you, everybody. So what we do is we have one more case.
Excuse me, Mr. Chair. I don't know if the appellant would like to rebut any of the...
Oh, that's a good, okay, well, we'll leave it open then for the
I mean,
repellent.
Yeah, if they...
Mr. Gunling, did you want to come forward and say anything in response to some of the remarks you heard from the opponents? No, he doesn't. Okay, thank you. That's a good question. Okay, with that, then we'll go ahead and close the public hearing. And so what we do is the board, we have one more case on the agenda tonight, and we'll take the input on that case, and then towards the end of the meeting, we then do our deliberations, and sometimes people stay for that, and sometimes they don't, so you're welcome to stay. Is it on TV right now? We don't know. Okay. So you're welcome to stay. Otherwise, if you don't want to, you can certainly check in with Allison tomorrow, and she'll give you the results. So with that, we'll move on to the next case, 12-2014 BZA for 7424 Gungadin Drive.
The applicant is Philip von Herzenberg, who's the property owner. The property is zoned B residence, and the variance requested this evening is from section 51.1-1 of our zoning resolution to allow a utility trailer to be parked within the front yard area where it is required to be located within the rear yard. I have a location map of this subject property with it highlighted. The surrounding zoning on all sides is B residence, and the uses are single-family residences. We have an aerial photo of this site, again with the property highlighted. The applicant owns a single-axle open utility trailer, which is used to transport lawnmowers for his landscaping business. The trailer is currently parked in the driveway behind the applicant's truck during the mowing season and stored off-site during the cooler months. The zoning inspector was in the neighborhood on another call on September 4th and inspected this property as well on the way and found that the trailer was not in compliance with Section 51.1-1 of the zoning resolution. Follow-up inspections found that the trailer was removed from the property for work, returning with the truck at the end of the day. The applicant filed for a variance on October 17th, 2014. We have property pictures provided to us by the applicant of the subject property. Staff finds that the property in question will yield a reasonable return without the variance. The single-family home can still be used as a residence without the variance. The essential character of the neighborhood would not be substantially altered as a result, or would be substantially altered as a result of the variance. Parking a boat, trailer, mobile home, or junk auto within the front yard area where the driveway is in question located is prohibited within any residence district. The property owner's predicament can be feasibly obviated by some method other than a variance. The trailer is currently stored off-site during cooler months, and the applicant can park the trailer off-site during the mowing season. The spirit and intent of the zoning requirement would be observed and substantial justice done by not granting the variance. The driveway where the trailer is currently stored is within the front yard and directly visible to passing traffic.
Okay, thank you. Any questions of staff on this one, this case, the trailer? Okay, is the applicant, would the applicant come forward, please? Give us your name and address, please.
Phil Von Hertzberg, the property owner at 7424 Gungadin Drive.
Do you have anything else you'd like to add to what Allison said?
She summed it up pretty well as far as what I'm looking for. It does state that it's stored off-site in the cooler months. I have a friend that lives in Westchester, so that's not really something that can be done on a daily basis. As she stated, it is for business. It leaves every day. I have no access to the rear of my yard to store this trailer on my property. My side yards are not that big without me interfering with my neighbors, and I really don't want to put anything in the grass as far as tearing up the grass and making it an eyesore. I don't think the trailer sitting in my driveway would affect the visual aspect of the neighborhood as much as tracks down my side yard and in my neighbor's yard, and I don't want to go that route.
Okay, thank you. Any questions for Mr. Von Hertzberg?
I think you said here that the trailer in no way will fit in the existing garage.
Correct. It is too long. My garage is very short.
I'm looking at that picture right there, and there's a lot of stuff there.
Yes.
And I just want to make sure that you're telling me that the dimensions of your trailer are longer than
Correct.
the inside dimension of the garage.
Correct.
Okay, thank you.
What is the dimension of the trailer?
It's listed as a 7x12 trailer, but it ends up being close to 18 feet with the tongue and the rear gate.
With the gate down or?
With the gate up.
The gate up, it's 18 feet. And how long is the garage?
Just under 18 feet.
Under 18 feet. Who else has questions for the applicant? Anybody?
I have a couple.
Yes, Mr. Johnson.
Where do you put the equipment when you go home?
It's in my garage.
I was also wondering how long the trailer was. Now, the county auditor has the garage as being 20 by 21.
Correct, and it is not.
Okay.
Those are probably outside dimensions.
That's what I thought, because the overhang in front of the garage goes further. Because I looked that up too, I'm like, there's no way that's what it is.
Okay, who else has questions? Are there any more questions for the applicant? Okay, thank you. Okay, who else would like to speak in favor of the appeal? Yes, sir, please come up.
Hello, I'm Matthew Stang. I live at 7447 Gungadin Drive, across the street from the neighbor.
Go ahead, Mr.
And I'm not, I don't know Phil that well, but I can say that he places his trailer in the driveway square every time, unloads it every night. It is very well put in our neighborhood. When you're driving by, it doesn't look like it's just off to the side of the grass. It's very well, I want to say, maintained in the driveway every night. Second, I am the September 4th call that somebody complained about me having a trailer in my front driveway with fresh lumber on it, so I'd like to understand the zoning requirements for how long a trailer can sit in a yard before somebody has a problem with it. And third, and last, we have at least 5 other zoning violations in our neighborhood, one within 4 houses down that don't seem to have any trouble. And it's a parked car in a driveway that nobody seems to complain about, and I don't care about it either, so I don't know why anybody's complaining about trailers in driveways. If it's a boat trailer, if it's a camping trailer that's seasonal, I can say yes, but I would be in favor of revising the zoning restriction on a utility trailer of a certain size.
Okay. With regard to your questions, great questions, but we don't really administer the code here. We're the appeals board, but Allison can help you with those questions. Just, you can talk to her after the meeting or give her a call, and she can tell you that kind of sometimes that kind of thing's hit or miss, you know, depends on who sees it. I can tell you that.
I told the zoning auditor, and she refused to listen to my question because she said the vehicle is tagged. And if you look at the zoning requirements, a junk vehicle that's been parked in the same spot for over 30 days is considered to be in violation.
Right. So
And she disregarded my
there's lots of nuances
statement.
to the
But I don't care. I'm
enforcement,
just,
so.
it's, I want to say a few other words, but I'll just.
There was
keep it.
I noticed when I was out there, there was a trailer parked on the street, too.
That's mine.
That's your trailer?
It is.
Parked on the street?
I mean, I don't see a zoning requirement that says I can't park my trailer on the street.
Okay. Any other questions for Mr. Stang? Okay, thank you. Who else would like to speak in favor of the application? Anybody opposed to the variance request? Okay. Go ahead and close the public hearing then on that.
I have a question I guess, for staff. So there wasn't a complaint for this one?
No, there was not.
It was just an inspector was out for something else?
Typically, when people call in, they don't know the house number of where something is, and they say, my neighbor's got a trailer on Gungadin. So Barb goes out to inspect and was looking for a trailer and found 2.
She got 2 for 1, huh? Okay. All right. Okay, so the public hearing closed on that one. So let's jump back to 11/2014, which is the outdoor fireplace setback. And let's discuss that one, see what the board's thinking on that. Would somebody like to jump in on that?
Yeah, I wanted to note for the board's information is that the original plat that we have here that is supposedly in error is a building permit plan. It's not an as-built, but was a design drawing so that a developer, home builder could put the house on the property and demonstrate side yards, rear yards, and whatnot. So I'm not surprised that we have 2 surveys and that they're in variance of one another, because the second one that we have that was done in October of this year is an as-built, where the other one was a design drawing. And that the contractor relied on a dimension from the house rather than a dimension from the property line. So I tend to look at the owners as taking some burden here. At first, I was thinking, well, we've got 2 different surveys. I don't know which one's true or which one's not. But upon further reflection here, we have a design drawing which is not accurate, wasn't intended to be accurate. And we have an as-built here with the second one, which is accurate. So I think we have, I'm challenged here because what I hear is a solution to the problem is to, I think, jeopardize the quality of the project and to jeopardize the quality of the view from the neighbors. And yet I put greater burden on the owners and the contractors for where the fireplace is located, because they were not using adequate information, and I put that burden on them.
I do want to point out this, the drawing that says Zickawacker Homes, it's page 6 out of this. The survey stamp for that is on the next page. It's split between two sheets.
Right, it's the January 19th, 2004.
But it is a stamped survey.
Right, that's why I asked the question as to when the house was built, was 2004.
And this is what we require to be submitted to issue a zoning certificate for a new home.
This right here. But this is not an accurate as-built drawing.
No.
Tough, because I don't see how we're going to be able to satisfy the concerns of the neighbors, I think in a win-win way.
I didn't really hear anything today that would indicate that the 8 inches is kind of substantial in terms of, this really doesn't seem to be about whether the setback is 2.4 or 3. The issues really seem to be about whether the contractor was sloppy and went on other people's property, and whether the drainage is right. Well, if the drainage is or is not right, I don't think that's impacted by whether it's 2.8 or 3, or 2.4, I'm sorry, or 3. That's a question for another jurisdiction, and it sounds like people have been talking to Hamilton County about the drainage. And the number of structures, the pool, basketball court, and things are otherwise in compliance with zoning. One might disagree with the way the zoning code is written, but we're not here, I don't think, to rewrite the zoning code. I think our decision is it a substantial, is there a justification for this variance, and whether, I can understand how it got set where it was, and undoubtedly it was a bit sloppy, and but I don't think there's a feasible way to obviate it, other than one that is, where the remedy is far worse than leaving it where it is. So I don't have a problem with granting this variance. I can understand some frustration of some neighbors over the whole process, and the fact that perhaps they're not thrilled at looking at a recreation complex, although a very nice one. But I just don't see the difference. I mean, I asked the woman right behind, does it make a difference if it's 3 foot or 2.4? And she said no. It was really other issues, I thought. So I would be in favor of granting the variance.
I completely agree, and the solution that I heard to obviate the discrepancy was to carve off the fireplace and make the view and the appearance far worse, and it would actually degrade the adjacent property owners more than just leaving it as is. And so that's how I came to the conclusion that I completely agree with you, Mr. Overschmidt.
I also agree with that. I thought that all the opposition was based on items that had nothing to do with the setback. It was, I didn't hear anything about, it needs to be 3 feet. It was everything other than that, and I think 8 inches doesn't seem like substantial variance in this case. And I really don't want to have them tear it down. If they did tear it down and move it to 3, all the other issues are still there. So I'm in favor of the variance.
Okay. I think everybody had some really great comments on that. Somebody like to make a motion?
Mr. Chairman, I move that in case number 11, 2014 BZA, that we approve the requested variance for the reasons that the variance is not substantial. It is only an 8-inch variance from a setback line, that the essential character of the neighborhood is not substantially altered and adjoining properties do not suffer a detriment as a result of the 8-inch variance. That the variance does not affect the delivery of governmental services, that the property owner's predicament cannot be feasibly obviated through some method other than a variance. There is extreme cost to moving it, and removing the stone from the back is something that's worse for all parties than leaving it as it is. The spirit and intent behind the zoning requirement is observed and substantial justice done by granting this variance, and that the, obviously the work is ongoing, that it be done in compliance with the plans submitted to staff.
Okay, so motion's second.
Second.
Motion and a second. Further discussion?
Yeah, let me say that I am going to vote in favor of the motion, primarily because I don't see a way to take care of what's already there. I mean, we can go ahead and take the stone off. We have a detrimental, I think, a worse solution than if we followed the variance. So I wanted to put that out there because I'm still looking at the owner and the builder for burden here, but I understand that we can't, there's no good solution.
Okay, thanks, Mr. Haber.
Yeah.
Any other comments before we vote? Roll call.
Steve Haber?
Aye.
Fred Hayes?
Aye.
Rick Oversmith?
Aye.
Brian Johnson?
Aye.
Brian Miller?
Aye. Okay, so that's approved. Thank you. All right, let's go on to the next case and have discussion on this one. 12/2014 BZA on Gungadin, the trailer in the front there. Just comments on that from the board? Don't everybody jump in there.
It's not always you. But go ahead.
Because I talk too much. Yeah, I guess my only concern with this is that we have the situation now where the person who's handling this does it in a very organized fashion and does a nice job and appears to back it off the sidewalk and all those kinds of good things, and keeps it off the grass and all those things. But I don't know. I'm just, somebody's going to have to get me a little more comfortable about this going down this path of, well, I don't know what's so different about this situation than many others if they came before us and said, we want to park a trailer in our front driveway. But I'm open to being convinced otherwise, but I'm just struggling with, I don't know if it's a precedential value, but the concern, and we approve it, and maybe the next guy's not as neat with his trailer and stacks a lot of other stuff up, and he's sitting here with a variance for this property. So I don't know, that's my concern. And
thank you.
Thanks.
Yeah, I'm kind of torn too. It seems that he's doing the best he can with the situation. nobody complained about it. But then it seems like it's a clear violation. I'm not really sure.
Well, in my mind, the zoning requirements are there for reasonable reasons throughout the township, is to maintain the conditions and maintain property values as best possible. And I completely agree with Mr. Oberschmidt, is that there's nothing unique about this particular situation that is any different than any other neighborhood anywhere, with the possible exception of there is no complaints or concerns of the close-by neighbors. But that could change as well if the neighborhood changed occupancy. So I'm also aware that the off-site storage may be inconvenient for daily use, but there's probably other off-site storage that they could be used and continue to run the business reasonably well. So I am leaning towards upholding the as-written zoning standards and denying the variance.
Okay.
Let me back off just a second of one thing, because there is one thing that's different here. And to make sure that I understand it correctly, if he had a broader side yard, just a couple feet wider, he could pull that around and park it in the back? Is that correct? And not be in violation of zoning?
Correct, if it was parked in the rear yard.
Which, you know, probably less attractive. So there is, I do want to backtrack a little bit and say there is a unique feature here, which is that they can't get that to the backyard, even though they'd be allowed to park it in the backyard.
Right, I thought about that as well, and it is nicely kept. It's a nice street. But I would say that that's the situation for a lot of houses, that there's not side yard room to get the thing around, especially if you have a bigger trailer or something like that. There's a lot of places where it's not going to fit. So then if you can't have that pathway, then is it going to set a standard? Then everybody just doesn't have a pathway. Or in this case, happens to have a trailer that's a couple notches too big to park it inside, and it has to go outside. Could be pretty big exception to the rule, it seems like.
Are there limitations on parking it on the street?
Zoning does not handle anything on the street. It's all through the sheriff's department.
Because it's public right away.
So, but there very well may be laws that prohibit overnight parking of trailers on streets. But that's not in our purview. That's somebody else. And I guess the statute does not, our zoning statute doesn't distinguish between whether you're parking a boat, a mobile home, a junk auto, or a trailer. They're all considered the same. I'm just really uncomfortable with this.
Okay, is there any more discussion on this one? Some good comments? Would somebody like to make a motion?
Mr. Chairman, I move that in case number 12-2014 BZA, that we deny the variance to allow a trailer to be parked within the front yard area where it is required to be located within the rear yard. And the denial is based that the variance is substantial, that the property in question can yield a reasonable return without the variance, that the single family home can be used as a residence, that the essential character of the neighborhood would be altered as a result of that variance, as we've heard testimony today, that granting a variance would allow trailer, mobile home, boat, automobile, or whatnot within the front yard. The property owner's predicament can be feasibly obviated by some other method other than this variance, and we appreciate the fact that the trailer is currently stored off-site during the cooler months. And we hope that there would be an opportunity to park the trailer off-site during mowing season. The spirit and intent of the zoning requirement would be observed and substantial justice done by not granting the variance.
Is there a second?
Second.
Motion second. Further discussion? Roll call?
Steve Haver,
Aye.
Fred Hayes,
Aye.
Rick Oberschmidt. Brian Johnson,
Aye.
Brian Ellis.
Aye. Okay, thank you. Okay, we're going to try and journalize.
Mr. Chairman?
Yes, sir.
Since we have a denial on the one case, we usually don't, we usually send that to Gary so that he can.
Right. I was wondering if on 11, we were going to journalize that one since we approved it. Or no, we don't have to.
I'm guessing you're asking about 12, since we typically
No, I was
don't.
actually really
Okay.
thinking of the practical impact shouldn't hit the past applicant until next spring.
No, I was talking about the fireplace case.
Oh,
Did we
I
want to
was,
try?
I was more.
No, you were talking about the trailer.
The trailer.
Yeah.
For the trailer,
trailer
since we
will-
won't journalize it till next
hold
month,
off on
it'll
that
give
one.
him
So
that
next month, and by
to
then, he
find
will
other
have
arrangements.
parked it for the winter and then can figure out something for the spring.
Yeah. Take a quick recess and then come back and journalize.
Okay, we'll be in recess for a few minutes.
Will we have two separate meetings at that time?
We shouldn't, since you made it, we may have more evidence on that last one, but since you made a decision on that one, on the property maintenance appeal,
Do we have to journalize that decision?
Yeah.
That's what I was asking. We'll journalize that and
For the journalization, I think we can just do it all at once.
oh, because it's a denial. I understand that. Okay. So we're working on one here tonight further. Okay.
Okay, let's go ahead and review this and see if it looks good. Ready to scroll up?
Slightly, don't go all the way.
Just slightly. There we go.
The one thing I thought the owner had in his favor was the fact that he went over to his neighbors and said, how about I just buy the 8 inches? I thought that was good.
Yeah.
Sounds like he brought it up, actually, with the neighbors.
He was buying the fence when he did that, though, too.
Yeah.
But I knew when the neighbor refused that this was a broader dispute. This was just a grievance.
I don't know if we have to add into two, that there was testimony that, the sentence above that, after the first sentence or two, there was testimony that 8-inch difference would not impact the view from the adjoining properties, or, the types of questions that we ask.
That's critical.
Thank you.
Is that too passive?
Well, I don't think it was that they
Why don't we just
would
say-
not have any impact, I would say.
Significantly changed impact.
Yeah,
Not have significant impact?
yeah.
That's good.
Mhm. I'm sorry, was there testimony that there's similar amenities around, or is that in the staff
It's in the
remarks?
staff.
Okay, gotcha.
Although the people behind them do have a pool.
At the very end of that paragraph, would you all be willing to add a few words there that say that leave an unattractive view for surrounding properties, resulting in a worse situation for surrounding property owners?
You want to talk about lowering property values?
Lowering, well, that's probably...
Maybe just a
conflicting,
maybe a greater negative impact on the properties.
Greater negative impact would be fine.
Okay, that's good.
I would just maybe reword that one up about 3 from there, the adjacent owner's not interested in selling. I just would maybe, that's the right idea. I'd say the appellant attempted other means to resolve the setback, such as purchasing additional property, but he wasn't successful.
I'd say purchasing the difference instead of purchase the whole property.
And, yeah, I think relocating the structure is, should be deleted there.
Yeah, I'd
Because
take that out.
That's too far.
That's the other sentence, though. It used to say the cost of relocating the structure was prohibitive. So maybe we don't need to talk about that at all.
I'd just take that out, I didn't really,
That's good as is.
Fine with that.
Okay.
Do those drawings show a 2'6" or a 2'4"?
2'4". The confusion came because all of our conversations with the applicant were 6 inches, not 8.
Oh.
Okay, so the drawings do show 2'4".
In teeny, teeny, tiny.
Teeny, teeny, yeah, I know, I couldn't even see it. Okay? So we're okay when we see it.
Somebody ready to make a motion?
Mr. Chairman, in the, regarding case number 11-2014 BZA, I move we approve and journalize.
Second.
Motion second, any discussion, further discussion? Roll call?
Steve Haver?
Aye.
Fred Hayes?
Aye.
Rick Emerson?
Aye.
Brian Johnson?
Aye.
Brian Ellis?
Aye. Any more business?
We can expect a meeting in early December?
Yes.
Third, I think, fourth, third or fourth.
For the 4th.
I may have problems on that, but there's a sufficient number here that we can proceed with those as is, right?
Holiday travel?
It's a holiday fundraising event that I'm too closely involved in.